The next thing we need to take a look at would be this advertising requirements. And now, at least right here, when we're talking about advertising, we're talking about advertising for lenders, okay? This is not like what you as an agent might be marketing or advertising. So if lenders are going to be advertising, you're obviously trying to get consumers to come borrow money from them. There are some requirements here when it comes to advertising, and you'll notice the first thing you'll see there are some things called trigger terms. And we call them trigger terms because in essence, if what the law is saying, if the lender uses any of these terms within their advertising, then there are additional disclosures that would have to be made to go along with it. Well, for example, I mean, the lender cannot just make a statement about something, tell you all the things that would be really good about this loan, and not tell you the bad. So basically what the law is requiring here, if you're going to tell some, then you must tell it all. You can't just state the good parts and not disclose what might be considered negative or a bad part. So that's what these trigger terms are. Things like the amount of a down payment, the amount of a payment, number of payments, period of repayment, amount of any finance charge. Anything, those types of things are considered trigger terms, which means if you're going to, for example, if you're going to put in your ad the amount of a down payment, $1,000 down payment, well then there's some additional disclosures that have to go with that. Oops. Such as the amount or percentage of the down payment, right? Obviously if it's a $10,000 loan and you're putting 10% down, then that would be $1,000. Well, you can't just say you require $1,000 down payment. You have to express what's that percentage of the loan amount. Now look, with all that being said, here's what you need to know for test purposes when it comes to advertising. This is all you really need to remember. If the lender uses any trigger terms, and they'll probably state it something very similar to that on the exam. If they use any trigger terms in their advertising, what else might or must be required? And the answer they're looking for is additional disclosures, or additional information. So anytime trigger terms are used within advertising, there's some additional information that must be provided about that, whatever the trigger term is regarding, or disclosures or what have you. That's all you need to know. Trigger terms, additional information, or disclosures are also required. And I think you'll be okay for test purposes. All right. Then we take a look at these. It's called TILA RESPA Integrated Disclosures, or the acronym you hear most often used is TRID. This is a financing law. And, and I kind of, especially if obviously you're going to be new. So, we need to talk about why TRID even exists. All right. And the reason it exists, back in, what was it, in 2008, 2009, somewhere in that neighborhood, we had, the real estate market just absolutely crashed. A lot of reasons for it. Not going to get into that. It's not relevant for what we need to go into right now. But the fact of the matter is the real estate market crashed. We had an insane, record numbers of foreclosures all across the country. Okay, now some states were hit harder than others, But y'all, this affected the entire country. Y'all, just record numbers of people losing their homes to foreclosure, and the market crashed. I mean, you actually had, in some places, you had, the value of your home might have dropped 50% or more. It was just a pretty rough time. But basically, when media, for example, would be interviewing people being put out of their home due to foreclosure, they'd ask, how do you feel, what happened, so forth. And what we were finding out is pretty much nobody was accepting responsibility for what was going on. And I'm talking about the homeowner. Even the homeowners, they weren't able to make their payments. Obviously, you don't make your payments, bank's going to take the house. Well, that happened all over the country, record numbers of times. But it was interesting what the homeowners were who they were blaming. And it was basically everybody but themselves. They were saying it was the lender's fault for loaning me more money than I could afford. It was the real estate agent's fault for pushing me into buying a house that I could not afford. It was the appraiser's fault for overvaluing the property when it was appraised. And so forth. Just pointing fingers everywhere except for here. Well, all this was taking place right about the time, excuse me, right about the time President Obama took office. And one of the things the Obama administration did when not long after taking office was to introduce and implement this new law. The law called TILA RESPA Integrated Disclosures, or TRID, that we refer to it. TRID changed how we do real estate, especially when it comes to closing. It changed a lot on how we do things, and I got to tell you, when this first came out, people were up in, basically nobody liked this law. Nobody. Real estate agents hated it. Lenders hated it. The attorneys hated it. But I gotta tell you, I kind of liked what these new requirements were now. And we're about to go over these requirements. But I did want to give you a little bit of background on why these laws exist. And I will be doing a little bit of compare and contrast, to try to make sure you understand why we're doing what we're doing. Now, there's a couple things about this law that I got an issue with that you're going to hear about. You'll see here a little bit later. But for the most part, I like the law. And I will tell you what we have now found out, the reason everybody hated it is because it caused us to change how we do business. Nobody likes change. And this wasn't just, this was significant changes. So all the more reason not to like it. So I don't think they didn't like it because of what the law required. They didn't like it because we have to change so drastically what we're so accustomed to doing. So anyway, prior to TRID, the settlement statement that you typically would see used at closing, the settlement statement was called the HUD-1. Obviously, we don't use the HUD-1 anymore, but I got to tell you, I hated the HUD-1. I wasn't even sure how the HUD-1 was even a legal document, to be honest with you. I absolutely hated that document. Because if you've never used or seen a HUD-1, it was one sheet of paper basically with a line right down the middle. And on one side, you had everything, all the financial pieces of this puzzle about the seller in this column. And then in the other column right next to it was all the financial pieces for the buyer. So you had all the buyer stuff and all the seller's financial stuff all on one sheet of paper. I hated that. If I were a buyer or seller, either one, if I were the seller, there's things on my column I just assumed the buyer not know. It's none of their business how much I'm making or what I'm doing here. And quite frankly, if I'm the buyer, there's things in my column the seller has no business knowing. I always thought there was a lot of confidential information that's now that we're now forced to share with the other party. So I never liked that form. Never did. Well, this to me was a very big positive, because now the HUD-1 was replaced with what we call a closing disclosure, or CD. The reason I think it's so good is because the buyer and the seller will each have their own CD, or closing disclosure. The seller will not see the buyers, and the buyer will not see the sellers. It's now separate. It's two different documents. So all the transaction cost, all the debits, all the credits, whatever you're paying, whatever you're receiving, is now kept for yourself. The other party is not privy to what's going on here. So I like that. I absolutely love that. Well, another significant issue that we had, again, prior to TRID, the law did state that the settlement statement would have to be received by the buyer a minimum of 24 hours prior to closing. Because the buyer has a right to look and see what all the debits and credits are. They had a right to see the settlement statement before they were asked or required to sign off on it, right? So the law said the buyer must receive a copy of that settlement statement a minimum of 24 hours prior to closing. So they could verify the information on it. Obviously, if you're just now taking the class, you probably weren't doing it. But the reality is the buyer rarely, at least in my market, the buyer rarely saw, much less received, a copy of the settlement statement 24 hours prior to closing. In fact, probably 80, if not 90% of the time, the first time the buyer actually got to see the settlement statement is when we were actually sitting at the closing table, ready to close. It was the first time they ever saw it. Well, how can that happen? I thought we just said the law then required it must be provided a minimum of 24 hours prior to closing. Well, there was a caveat in the law that most people didn't, I don't think, realized existed. But for some reason, we just closed anyway. Forget what the law says. We're just closing anyway. The reason we closed anyway is because there was a provision or caveat in the law that said if the buyer does not receive the settlement statement 24 hours prior, then basically it's up to the buyer on whether they want to close or not. They can just go ahead and close, or they can demand we put it off for another 24 hours. In fact, it was just never even discussed. Not in the market that I work in. We just never discussed it. We just went with the assumption, buyer, you want to close, get in your car and be there in time to close. And we'll show you the settlement statement when you get there. I guess, that's how it kind of worked. Well, now that's changed. Now under TRID, the law is the buyer must receive their settlement statement, or what we refer to as the closing disclosure, a minimum of 72 hours, 3 days prior to closing. And now under TRID, this cannot be waived by the buyer. If the buyer does not receive their closing disclosure a minimum of 3 days prior to closing, you're not closing. We will have to push closing back. There has to be that 72-hour or 3-day period before you can close. Now, apparently there are some exceptions to that rule, because I have been told, I've had people tell me that buyer didn't get it within 3 days and they still closed. Y'all, all I can tell you is what the law says, and that's what you need to know for test purposes, okay? And I suspect that could very well be a test question. How long must you wait before you can close? 3 days. Y'all, they have to receive that closing disclosure a minimum of 3 days or 72 hours prior to closing. Y'all, the next thing TRID did is, y'all, it did away with what we used to refer to as a good faith estimate. Y'all, that's what it used to be called prior to TRID, a good faith estimate. And basically the law back then required that the buyer must be provided with this good faith estimate, which lists or is supposed to list all the costs associated with the loan, right? And y'all, obviously if you know what all the costs are and you know what the loan amount is, then you could derive or determine what that annual percentage rate would be. Y'all, we talked about that in an earlier hour. But y'all, the APR, in my opinion, is the most critical piece of information about borrowing money. Y'all, that's what tells you what it's going to cost to borrow the money. But here was the problem. Even though the law required lenders to provide a good faith estimate, the law did not require that it be accurate. I know that sounds insane, but that's a fact. And because of that, when the borrower was given that initial good faith estimate, it did not include all the cost. In fact, in many cases, it didn't include many of the costs, not many at all. So that made the APR look much better than it actually was. They didn't find out what the actual costs were going to be until they actually were sitting down at the closing table. And by that time, nobody was paying attention to anything. Where in their good faith estimate, it might have said your APR is going to be 6%, but the reality is it was closer to 7 or 7.5%. To me, that's just lying. To me, it should be fraud. Good news is, again, TRID hopefully has fixed that problem. Two things there. Now, under TRID, we no longer call it or refer to it as a good faith estimate. Now it's called a loan estimate. Now, why they have to change the name, I don't know. I guess got to feel like you're getting paid to do something. But they changed the name to just a loan estimate. But the law also requires now that when the lender provides that loan estimate, which they are required to do, it must be accurate. In fact, the law even goes as far to say that if you underestimate the cost of this loan, if it's not identified on the loan estimate when you give it to the buyer, you cannot go back in later and add it in. So in essence, if that lender forgets or does not include something in that loan estimate, lender, you're going to have to eat that one. You're going to have to eat it because it cannot be, you cannot increase the cost after the loan estimate has been issued. Can't do it. So, again, I think that's an awesome idea. I like that a lot. And then obviously at the end of the loan estimate, that should give you that APR, the annual percentage rate. We discussed that a lot in the previous hour. So hopefully you understand that. But please also understand, the APR is not the same as the interest rate. Those are two different rates. In fact, I hear that asked at closing a lot. They'll be looking at their loan estimate and it'll say, well, wait a minute, this says 7.5%, and I was told my interest rate was going to be 6.5%. Okay, well, your interest rate is 6.5%. What you're looking at, buyer, is the annual percentage rate. That's not the same thing. But I'm going to tell you, a lot of people get really bent out of shape. To the point where they refuse to close because they don't understand it. And I will also tell you, if somebody is doing, if the buyer does that at closing because they're confused and they don't understand it, if it's me, I'm going to be looking at the buyer's agent dead in the eyes. Why don't they understand? Why are we sitting here at closing and they don't understand what they're looking at? Because y'all, if you're that buyer's agent, there's a reason you're supposed to get this document 3 days prior to closing. Y'all, you need to go over this settlement statement with your buyer. Make sure they understand it. In fact, y'all, your buyer should not have any questions because you've already answered their questions before we get to the closing table. And when the buyer shows up and they don't know the difference between the interest rate and the annual percentage rate, y'all, that's pretty clear to me. The buyer's agent did not go over any of this stuff prior to closing. If it were up to me, I think you should have to forfeit your commission. You didn't do your job. You didn't do what you're supposed to do. So anyway, y'all, we got a chapter later on dealing with closing details. We'll talk more, get more into that aspect of it. But here, I just wanted to lay out some of the significant changes in the law due to TRID. So, y'all, that was kind of a lot there, but here's what you want to make sure you remember for test purposes. Both the buyer and the seller will now receive their own closing disclosure, or CD. Sometimes they use that acronym. And the closing disclosure is, in effect, the settlement statement for the buyer and then one for the seller. The buyer must receive a copy of their closing disclosure a minimum of 3 days. Well, potentially they might say 72 hours, but we know still 3 days prior to closing. I would remember that. And I would also remember that the lender must provide the buyer with a loan estimate, and all the cost must be there. Because once they issue that loan estimate, they cannot come back and then try to add additional costs to it at sometime prior to close. You can't do that. All right, that's what you need to know there. So, y'all, some loans are affected or must comply with these laws of TRID. Some do not. But, y'all, obviously the ones that must apply are what we call closed-end mortgages or closed-end loans. Y'all, I'm not going to get into detail here, but a closed-end mortgage is when you borrow money to purchase a property. If you borrow money to purchase the property, that's a closed-end mortgage. Remember, we talked about another type of loan earlier called an open-end mortgage, not closed-end, but an open-end mortgage. Remember, we said an example of an open-end was like a home equity line of credit, a HELOC. A HELOC, you're not borrowing money to buy a house, you're actually borrowing or using some of the equity out of your home. So that's considered open-end. It's not a closed-end mortgage. One reason that's important, y'all, you see there's 3 types of loans that are exempt from TRID, meaning these disclosures are not required on these 3 loans. And they specifically spell out in the law, these 3 loans, these disclosures are not required. One is the HELOC, y'all, the open-end mortgage, y'all, that's a home equity line of credit. If it's a loan for a mobile home, TRID does not apply. And here's the one that gets me, that really irritates me about TRID. The reverse annuity mortgage, y'all, the RAM. They intentionally listed this loan as one you do not have to disclose what's going on here. Y'all, that ought to tell you something about this loan. Y'all, I kind of voiced my dislike about these loans when we were going over it in an earlier hour. Y'all, this ought to tell you about all you need to know. Y'all, because we know this is a government loan, and when the government intentionally lists this as an exemption, you don't have to disclose how this works. Y'all, that ought to tell you something about this loan. I don't know of another loan that should require more disclosures than this one. but yet the government side, we're not going to make all these disclosures for that. But anyway, y'all, those are the 3 loans that are not required to have all these disclosures under TRID, okay? Might be, y'all, they could probably ask you that. Which of the following loans are exempt or do not apply, or does TRID not apply to? And y'all, there you go. All right. Now we move into some other disclosures that are required, y'all. If these issues exist, y'all, these are mandatory disclosures you must make prior to closing. One is if there are any affiliated business arrangements. Well, what is an affiliated business arrangement? Y'all, a lot of real estate companies, y'all, especially larger companies, but quite frankly, it could be small ones too. But a lot of real estate companies have basically gone into business with one or more settlement service providers. For example, a lender. Y'all, we talked about, again, in the previous hour, we know kickbacks are illegal. Remember, y'all, you cannot refer business to a settlement service provider and receive anything of value in exchange. Y'all, there's nothing wrong with making the referral, but you cannot receive anything in return for the referral. Y'all, it doesn't even have to be just money. Y'all, the law says anything of value. In fact, you're getting ready to see it here in just a second. But y'all, that's illegal now. So we figured out a way to get around that law, and we call it an affiliated business arrangement, where maybe the real estate company and a lender get together and form, say, an LLC. Y'all, they create an LLC where, say, the real estate company owns half of it and the lender owns half of it. And basically what they're doing now is they're conducting loans through the LLC. So a real estate agent might tell a potential buyer they're working for that if you're looking for a lender, we actually have an in-house lender that does an awesome job, yada, yada, yada. And then the buyer decides to just use the in-house lender because you suggested it, they trust you, and so forth. Well, because of this business arrangement, and because the real estate company actually owns interest in this LLC, y'all, any income produced through the LLC, now the real estate company would be entitled to some of that income, right? Based on how much interest they own. So in essence, the real estate company is now also making money off the loan that the buyer gets. Now, legally, that's fine. Y'all, and I'm not in any way trying to suggest there's anything wrong with that. But what I am saying is that's a mandatory disclosure. So you better tell that buyer. You can't just say we have a preferred lender right here in-house. In fact, they're right here, right beside us in the office next door. If you want, let's go in there and talk to them. Yeah, and all that's fine, but then you must also disclose to them. If you decide to use this lender, we just need you to know that there is a business arrangement between the real estate company and the lender, and the real estate company will be making money off your loan, in addition to whatever commission we make on the house that you buy. So basically, they're making money on the sale, y'all, the commission, and they're making money off the loan through this business arrangement. Again, it's legal to do this as long as it's disclosed. And by the way, and I know I've said this before, but just as a reminder, y'all, if you have to disclose something, will it be sufficient just to tell them what I just said? No. Y'all, if you're ever audited or investigated and you don't have that disclosure in writing and have them sign off acknowledging that you told them that, then you didn't tell them. Y'all, you can plead and cry all day long, but I did tell them. They did know it. Y'all, if they didn't sign something acknowledging you told them, then you didn't tell them. All right, y'all, and then it talks about some of the prohibitions. Y'all, obviously a prohibition is something you're prohibited from doing. But y'all have already been talking about it, but this is where you kind of see it in writing. Y'all, it prohibits a real estate agent from receiving, and you notice they put in parentheses, anything of value. Y'all, 1 penny is considered value. So you can't say, but it's only a couple of dollars for what? That's something of value, and you cannot receive anything of value in exchange for referring that business. Okay? Y'all, so that would be a no-no. Make sure you're not receiving anything of value in exchange for referrals. Nothing wrong with referrals, but the only reason you should be making that referral is because you know them, you trust them, and you're just trying to help your client get the right person to help them, I guess. All right. Here you see the Equal Credit Opportunity Act, and y'all, basically this is the law that says thou shalt not discriminate in finance. That's what the Equal Credit Opportunity Act does. Y'all, you cannot discriminate in finance. If someone is denied a loan, y'all, and obviously people are denied loans all the time, and hopefully for valid reasons, because they can't afford it, they can't, or whatever the reason is, it better be valid. It should not be, or better not be, discriminatory. But what the law requires here, if anyone is denied a loan, y'all, they must be notified within 30 days. Okay? They've got to be notified within 30 days of denying the loan. Now, why it would take that long to let somebody know they're denied, I don't know. But I get this question a lot. Do they have to notify the consumer in writing of why they were denied the loan? No, y'all, the law does not require it to be in writing. They just have to, they do have to notify them, but it does not have to be in writing. In fact, y'all, when I've had clients that are denied a loan, typically the way they're notified is the loan officer just calls them up and just says, hey, Frankie, y'all, we've run the numbers, and for whatever reason, for this reason, y'all, they got to tell you the reason. Maybe it's your debt to income is just too far out of whack. And right now, we cannot do the loan. So basically, you're denied. So they just tell you. They usually just call and tell you. But hopefully if you got a good lender, they might say, we can't do the loan right now, and here's why we can't do it. Maybe your credit score is too low, your debt to income's out of whack, whatever the case may be. But then hopefully if you got a good lender, they'll say, but here's what we need to do to get you qualified. And here's how we're going to do it. Here's how long it's going to take. Yada, yada, yada. I know the lender I like to use, she's awesome with that kind of stuff. And she really works hard trying to help them get approved. All right. But that's the Equal Credit Opportunity Act. I remember that. That's the law that says you cannot discriminate in finance. And then we look at some types of mortgage fraud. A lot of times you get referred to as predatory lending. And here's what you need to be aware of. Some states, and again, this is another one of these areas where when we get into the state-specific parts, we're getting a little bit more detail about the requirements in whatever state you're in. But some states have actually passed what we call usury laws. That word usury is important. If you're not familiar with that term or don't know what it means, highlight it. Make sure you know it. That's a testable term right there. Usury just means charging excessively high rates of interest. We're not just talking about the interest being high. We're talking about being excessively high. That's considered usury. We're charging excessively high rates of interest. Well, some states have passed what we call usury laws, meaning they have actually capped, y'all, they put a cap on how much interest you can charge on loaning money. Again, some states have done that. A lot of states have not done that. In fact, what you'll tend to see a lot of times, especially in states that do not have usury laws, they probably have some law that will say something to this effect. Basically saying there is no maximum rate of interest to be charged as long as it's in writing and agreed to by all parties. Y'all basically say, look, if you agree to pay 100% interest, even though most of us would consider that to be extremely excessive, if you agree to do it, then you got to do it. But the law would probably say, that must be in writing. But if both parties agree in writing to it, then so be it. But if it's not in writing, y'all, I think most states will at least have some law that will cap how much interest you can charge on an oral agreement. Where if it's just you with a handshake, they might, just for example, they might say the most you can charge is 6% interest if it's not in writing. But as long as you put it in writing, whatever the parties agree to. But then some states, again, have passed these usury laws. I promise you're going to hear that term again, which means they have put a cap by law on how much interest can be charged on any loan. But then, y'all, there's this thing called predatory lending. And basically, y'all, it's what it sounds like. Y'all, this is where you have, I guess you call them lenders, but it's typically not your known lenders, or your well-known lenders. These are like loan sharks, if you will. But this is where they basically loan individuals money pretty much knowing there's no way they're going to be able to pay it back. Y'all, because of the terms, because of the high interest, the fees associated with it, they're already in financial trouble, right? Otherwise, you just go get a normal loan. But no, now you're going through some other, I'm using the term loan shark, because that's in essence what they are. Y'all, they're just preying on consumers. I was about to give some examples, but I won't. Y'all, in the purpose of this video, I don't want anybody to be mad at me, but you better be careful about some of the stuff you see on TV about, again, I'm not going to get into it. A lot of this stuff is predatory lending. You better be careful with it, because I'm telling you, the terms will be set up in a manner that it's almost impossible to pay the money back. And they don't want you to pay it back. They'd rather take whatever you put up as collateral. That's what they want. They don't want you to pay it back. So they'll set these terms up in a way that is virtually impossible to pay it back. That's predatory lending. But then we need to talk about foreclosure. I'm sure everybody knows what that means. If you don't make your payments, you borrow money to buy a house and you don't make those payments for whatever the reason, then you're probably going to lose the house. The bank's going to take the house from you. Now, how do they do that? Well, they foreclose. If you recall earlier, we talked about some states operate under lien theory, and other states operate under title theory. Well, states that operate under lien theory, that means the borrower will get the title to the property at closing. Well, if they quit making their payments, or for whatever don't make their payments, now the lender's got a problem, because there's nothing they can do with the property if they don't own or have title to the property. Well, in lien theory states, the borrower has the title. So basically, the lender is going to be required to file a foreclosure notice, which is a legal process to basically get title to the property back. Now this can happen in a couple different ways. Y'all, there's different types of foreclosures. This first one you see here is what we call a judicial foreclosure. And it means the mortgage lacks a power of sale clause. Well, what does that mean? Y'all, we're getting ready to talk about that here in just a second. But y'all, if we do not have the power of sale clause, which is typically what you would see in a lien theory state that I was just referring to, because the buyer has title, then there's not going to be a power of sale clause. So now it says the foreclosure has to now go through the courts, because y'all, we got to get title back. Well, what is this power of sale clause? Y'all, if it's in the mortgage, then it says the lender can just sell the property to pay off the debt. They do not have to go to court over it, y'all, because the lender already has title to the property. They already have title. And if I have the title and I go ahead and put in the mortgage, if you don't make your payments, we can just immediately sell the property to get our money back. Y'all, that's the power of sale clause. So if you're in a lien theory state, this power of sale clause is not likely going to be there. Y'all, they can't, because they don't have title, so they can't just sell it. But if you're in a title theory state, y'all, then they could put in the power of sale clause. I'm not suggesting that all lenders will do that, but they can do that. And if that clause is there, then they can just sell the property. Y'all, then when you see the non-judicial foreclosure, y'all, that says the mortgage or the deed of trust contains the power of sale. Y'all, we were just talking about this. So basically, you got a judicial foreclosure and a non-judicial foreclosure. Judicial foreclosure means there's no power of sale. Therefore, the lender must go through the courts to get title to the property, and then they can sell it. But with a non-judicial foreclosure, that means the title already belongs to the lender, already has the title. The mortgage includes the power of sale. We don't have to go through the courts. They can just put the house on the market and sell it. Okie dokie. Then there's the strict foreclosure. It says where the mortgagor gets a period of time to pay off the debt. And who's the mortgagor? Remember, that's the borrower. So they'll get a period of time to pay off the debt, and if it's not paid, then the title will be given to the mortgagee free of any rights of the mortgagor. Okay, y'all, I think that makes sense, but moving on. Then there's the deed in lieu of foreclosure, which is probably the best. Y'all, if you can't make the payments, you're not staying. Right? I would think people would be smart enough to know that. If you cannot or will not make the payments, you're not going to stay. Well, then why don't we just make life a little bit easier on ourselves and not deal with the foreclosure? Because I'm telling you, you don't want a foreclosure on your record. That's going to hurt you for a while. That's going to hurt. But what is this deed in lieu of? It says it's a document that transfers title from the owner to the lender in exchange for relief from the mortgage. Y'all, that's a no-brainer. Y'all, if I know I can't make the payment, y'all, I lost my job, y'all, whatever the case may be, look, times are going to be tough. Not only do you not have a job, you're now, in essence, going to be homeless unless you got family or friends or somebody you can move in with. But that's going to happen anyway. But at least if you don't force the lender to go through the legal system, through the courts, to actually foreclose, y'all, this would at least allow you to get back on your feet, get another job, and eventually you can buy another house. But if you got all this foreclosure stuff in your record, you're going to have a hard time getting another loan anytime soon. But basically what you're doing is saying, look, lender, I just can't make the payments. Here's the deed. I'll sign the house over to you if you will relieve me from the debt. And obviously, if typically, if the house is worth enough and there's enough equity in the home so that when they sell it, it would pay off the debt, typically the lenders will agree to do that. But what if the house is not worth the amount you still owe? In other words, the lender can't sell the house for enough to pay off the debt. Well, then an option there would be something we call a short sale, which is coming up here in a minute. Y'all about to get ahead of myself, so let's hold tight on the short sale. But before we get into that, there are two periods of redemption you need to know about, again, in regards to foreclosure. First of all, what is a redemption period? That's a period of time you have to pay off everything you owe and get and be able to keep the property. That's called a redemption period. Well, there's two types of redemption periods, and you need to be familiar with both of them. The first is the equity of redemption. Equity of redemption starts from the time the lender initiates foreclosure action right up until just before they actually sell at the foreclosure sale. That's your equity of redemption period. If you're able to somehow pay off everything you owe, to include late fees, legal fees, all that stuff, then you get to keep the property. But then there's also the right of redemption. And with the right of redemption, that starts from the time they actually sell the property at foreclosure. From the time they actually sell it, you have up to 1 year to come in and pay everything off, and you can get the property back. That's the right of redemption. Now, we'll tell you, not a lot of states will allow the right of redemption. Some states do, but a lot of states don't. So again, something we'll be talking about later in the state-specific part. I think pretty much every state does grant the equity of redemption, meaning if you can pay everything off before it sells, fine. But after it sells, that's the right of redemption. Again, some states will allow it, but a lot of states will not. And we'll get more into that later. And then, a deficiency judgment. If that house does not sell for enough to pay off what you owe, say you're $50,000 short. They sold the house, but you still got $50,000 still remaining on the debt. Then the lender could file a deficiency judgment against you. And basically that deficiency judgment becomes a general lien. If you recall from an earlier chapter, if you have a general lien filed against you, that means you'll never own anything the rest of your life until that's paid off. But with a general lien, they can now come and take anything and everything else you own until the remaining balance is paid off. So the last thing you want is that deficiency judgment. The best way to avoid all this stuff is to negotiate and talk to the lender. To try to avoid the lender because you can't make the payments and you don't want to talk to them, that's going to cause you more legal problems down the road. Don't want to do that. And then the last thing here, here's that short sale. I'm just going to kind of give you the skinny real quick on what a short sale is, but I'm telling you right now, do not, as a real estate agent, get involved with a short sale without extensive training, knowledge, and understanding on this process. I'm just telling you, there's a lot that goes into it, and this can get both you and your client in a lot of trouble if you don't know what you're doing. So I just want to put that disclaimer out there. Just know there's a lot that goes into it. We're not even going to scratch the surface on what all that entails, because you don't need to know it right now. All you need to know is this for test purposes. If we can't make the payments and the house is not worth enough to pay off what's owed, we're underwater, then we could request the lender to approve a short sale. And they will do some analysis, and basically, at the end of the day, if it's not worth it, then it's just not worth it. So what the lender may very well and will likely do, if you meet certain requirements, they will approve a short sale, meaning go ahead and sell it for as much as you can sell it for. And then whatever we sell it for, we'll use that to pay off as much of the debt as we can. Well, what about the remaining balance? Well, there are things you can do to work with that. I will tell you, in some cases, they may just write it off and say, don't worry about it. You worked with us. You at least tried to help us as best you could. We're just going to wipe it off your record. There's some other things you could do, but I wouldn't worry too much about any of that. All you need to know for test purposes, a short sale is when the lender approves the sale of a property for less money than what's actually owed. But that contract has to be approved so if you get an offer from the buyer, a low offer, and that's typically what you're going to get, the seller might say, I would approve it, or I would agree to it, but the lender has to agree to it also. So in essence, a short sale is subject to third-party approval. You could hear that a lot. So a sale that requires approval from a third party approval, we're dealing with a short sale. And who is that third party? The lender. Right? The lender, they know that they're going to have to sell for less than what is owed, but they're not going to agree to let you go down to some just absolute ridiculous price. So they want to have some say-so in the matter. So short sale does require third party approval.